Hello, welcome to our seminar today, the do's and don'ts of IP for ATMP. As a brief introduction, I actually had contact with Joanna discussing IP sort of issues around a specific product, and then in our discussion we were kind of like, but we need to get information out about how important this is and how people should look at their processes, their products, their research, and identify the IP and try to provide some prompts for people to think about this early in their product development. So we started working together to put together some information and identified some speakers through AWA, AWA, Anders Wilhelm Andersson, originally a Swedish company. And so today we have about 20 minutes of presentation from Ylva Wikmark, Joanna Applequist, hey, Joanna Applequist, and Louise Jonshammar. And then I have Mathias Svahn, because I'm not a pro in this field. So even though I'm giving you the intro now, Mathias's face says he's not a pro either. But Mathias has taken the journey of being an academic, having a technology, turning it into a product, turning it into a company, and having several products to my knowledge. And so Mathias will be running the discussion after the presentations to try to pull out some of those things that he would have liked to have known as an academic, some of the questions and tips that we could learn along the way. So I actually didn't give a very good introduction there. Ylva is a patent attorney, Joanna is a European patent attorney, and Louise is a senior attorney at law. And Mathias is the CEO of NextCell Pharma. So what we're going to do before we get into the presentations is a quick poll of who you are, a little bit of a get to know you. So if you could click on one of these categories. If you don't think you belong to any of these categories, just take the one that you think possibly suits you the best. You'll have about 30 seconds to do this, and then it will pop up with the sort of the distribution of roles that we have here. So this is more, I guess, even for our discussion to understand who you are and possibly where we should direct the discussion to as well. Oh, wow, check that out. So we have 63% academic and 38% private practice. So all the startups and SME, they think they understand it. That's nice. But thank you for that. So I will leave over now to the presenters, and then at the end, I'll come back with a quick little question to pass over to Mathias, and then we'll get into the discussion. And the discussion will run until about 5 minutes to 3, and then we'll have a short closing. So you have a chat function where you can leave questions. We'll try to get to them today in the discussion, but if we don't get to them, then we'll respond to you after the event. So feel free to leave as long-winded and complicated question as you like, because then we'll ignore it today and we'll respond to you later. Okay, so we start with Ylva, right?
Yes, absolutely.
Fantastic. Welcome.
Thank you, thank you. Can you change the slide, please? So, yeah, we thought we would start off this presentation with a brief introduction of what a patent is. Please, next slide, please. So, a patent is a legal right to exclude others from using your invention. It's a national right that you receive in exchange for showing your invention and teaching how it works. This exchange allows others to invent further using the disclosure of your patent, which is considered beneficial by states. So patents are negative rights. So having a patent gives you the right to stop others from using your invention, but it does not automatically mean that you may use your invention in a commercial setting. There may be conflicting rights that belong to others, or there may be requirements for regulatory approval and the like. And as I guess most of you know, the patent claims are the laws of a patent and define what the patent prohibits others from doing. A patent may be valid for up to 20 years from the filing date of the patent application, provided that yearly fees, renewal fees, are paid in the countries where you wish to maintain your patent. Next slide, please. So patents are granted for inventions. An invention is a technical solution to a problem. It may be a product, for example, a molecule or a cell line or a composition. It may be a process or a method, or it may be a use. And when an invention is born, the inventor automatically gets a right to patent that inventions. And this means that everyone who gets the same idea will also get the right to patent. But it is the inventor that first files a patent application that will obtain the patent in the end. And the right to a patent may be assigned by laws, by terms of employment, transfer agreements, union agreements, etc. And in Sweden, we have the professor's privilege, lärarundantaget, which means that teachers and the researchers at university own the right to their own inventions and may apply for patents on them. Next slide, please. So there are three main criteria that an invention needs to be fulfilled to be patentable. An invention needs to be novel, exhibit an inventive step, and it needs to be susceptible to industrial application. So it has to be novel and inventive in relation to everything that was publicly available on the day prior to the filing day of your patent application. This is the prior art. The invention has to be non-obvious to involve an inventive step. And this means that there need to be an inventive thought. It cannot be like the results of routine or optimization work, no matter how exhausting that work was. Lastly, the invention needs to be industrial applicable, which basically means that it can be made or used in industry. Next slide, please. So it's so important that you don't disclose your invention publicly prior to filing a patent application. An invention is only novel if it has not been described anywhere in the prior art. And we really mean anywhere. It does not need to be like published patent documents or scientific articles. It can be your poster at a conference or your oral presentation. It can be the abstract that you submitted to a conference. It can be your grant application or a clinical trial protocol, or anything that you find on TV or internet and the like. And it's not necessary that the public did access the information. It's enough that they could have accessed it. So don't disclose your invention when you apply for research grants, and ensure to have a non-disclosure agreement with any collaborators or investors and the like. I think Louise will briefly discuss non-disclosure agreements. And then I would like to talk a bit about the filing strategy, because in this field, the most common filing strategy is to file a first patent application, a so-called priority application, as soon as you have enough data on that the invention works. This application is filed in a country or region where the applicant is based, which for us then typically is in Sweden. So we file it at the Swedish or European Patent Office. So, and this application you will use to claim priority from. And within 12 months from this first filing, a second application for the same invention is filed, while claiming priority from the first application. And the second application is often an international, a PCT application. And this one is pending for quite some time, which allows for buying time while obtaining a patentability opinion from the PCT authority. And this delays the business decision on where to prosecute the application and postpone the costs related to the prosecution. But within 30 or 31 months from the first filing, it is time for this PCT application to enter national phase. And now you need to have chosen in which jurisdictions you want your patent. The application is nationalized into national applications in the different countries where you want your protection. And then at last, the national applications are prosecuted into national granted patents. And with that, I would like to leave the word to Joanna. Thank you.
Thank you, Ylva. Could we please jump ahead a couple of slides to the one that says patenting of ATMPs? Thank you. So we're now going to talk a little bit about life science and patenting of ATMPs in particular. Next slide, please. So in addition to the patentability criteria that Ylva mentioned, there are some special considerations that apply to life science inventions. For example, in Europe, there are legal exemptions to patentability based on ethical and moral considerations. So patents are not to hinder healthcare professionals in their professional roles, and they are supposed to allow for the provision of good patient care. So in Europe, methods of treatment, surgery, or diagnosis performed on the human body are not patentable. However, products used in those methods may be protected. In the US, on the other hand, methods of treatment are patentable, but the healthcare professionals are exempted from committing patent infringement in their professional roles. On the other hand, diagnostic methods are becoming more and more difficult to obtain protection for, as they are considered to relate to nothing more than natural processes occurring in the body. And the exemptions are also there to ensure that the human body and its parts, including gene sequences, are not patentable. However, in Europe, if those sequences are isolated from their natural environment, you may protect them. In the US, on the other hand, any product in any field of technology is not allowed patent protection if that product can be found in nature, and this is independent of it being isolated or not. So this all has bearing on what and how we can protect life science inventions, and there are variations between different jurisdictions. Next slide, please. So when you are a researcher or an inventor and you do experiments and you would like to protect your invention, it's always a balance between filing the patent early enough to make sure that you are the first one to file a patent to this technology, and on the other hand, collecting more data to build a stronger case. And especially if you're balancing this with an academic career and the requirements to publish and have PhD students and so forth, it is quite challenging. And that's why I think it's important to understand the function, the role of the data in a patent application. So data in an application is included for two reasons in principle. The first reason being that it's there to support that the claimed invention works as is described. On the other hand, data is also there to determine plausibility, that the invention will work as stipulated if it's based on extrapolation of data. And this could be, for example, if your invention relates to treatment of a disorder and you're not presenting clinical data that shows that it actually works. So if we set everything else aside, if we have a limited amount of data, that usually results in a more narrow protection scope. And broad data, on the other hand, results in a wider protection scope. So in order to obtain a wider protection scope, it's generally recommended to include many different examples of your invention instead of in-depth analysis of a few examples. Next slide, please. So the ATMP field is very quickly evolving, and along with it, patent practice is evolving, and it's adapting and developing. And unlike what we've worked with for a long time, like small molecules, which can be characterized by their chemical structure, or biologics characterized by their sequence or glycosylation pattern, cells of complex living entities, and both the patent practice and patent law has to be adapted, and also we're dealing with new business models. So there is a challenge to find good ways to protect these inventions that go hand in hand with these new business models. But despite the exceptions to patentability, there are multiple aspects of cell and gene therapies that are eligible for patent protection. So in general, genetic constructs, vectors, genetically manipulated cells are patentable. So for example, if a cell population is structurally or functionally distinct from previously described populations, it may in principle be patented. And for many therapies, claims directed to modified populations of cells expressing a specific construct are suitable, but also claims to the construct, the genes, the peptides, the vectors used for the manipulation, as well as patents relating to treatment of diseases and treatment regimens may play an important role in portfolios. And even when cell populations are not structurally or functionally distinct from previously known populations, protecting the methods used for obtaining those populations may be very valuable in this field of technology. And this could be methods for culturing, or differentiation, manipulation, or preservation of cells. Next slide, please. So when we define an invention, we use features of the invention to describe it. And basically, we work with two types of features. These are structural features and functional features on the other hand. So structural features, they describe the appearance, the physical properties of an invention. For example, a cell line might be characterized by the presence of a recombinant vector or expression of a recombinant protein. Then we have functional features, which deal with the functional properties, what the invention is able to do, what is it capable of doing. And if we're working with these type of features, it's very important to, in the patent application, describe how those features are measured. And also this type of features are heavily dependent on data presented in the application to show that the function is actually accomplished. And this could be things such as ability to induce an immune response, or ability to bind a target with a certain affinity. And it is important to understand that the fewer features are included in the claim, the broader the protection scope. So the more features, the more narrow protection scope, because there are more details about the invention that are mentioned. So we're going to have a brief look at 3 different areas with different technologies within the ATMP field. And there's obviously so much more to say than we will be able to do in these couple of brief minutes, but I want to mention a couple of things that you might need to ask yourself when defining your invention if you're working in these areas. May I have the next slide, please? And yeah. So if your invention deals with cell populations, then the challenge is to actually find a good way to describe your cell population, to identify features that actually distinguish your cell population from other previously known populations. So this could be with functional features. What does the population do? Does it do it better than previously known populations? And how can you quantify that? There could be the structure features, for example, features relating to the genetically manipulated cells, such as construct expression of a factor. And in biology, we often end up using markers to define populations in vivo and in vitro. And using markers in patents may work to some extent, but sometimes we are end up in situations where it's not really clear what is meant by a cell being positive or negative for a certain mark. For a certain marker, is it high or low expression? How do you define that? How do you quantify marker expression? And for example, if you're using antibodies for detecting expression of certain factors or proteins in cells, would you have gotten a different result if you chose a different antibody? So there is some ambiguity here. Other types of features could be proliferation rate, the source of cells, and so on. But the question to consider is, do your population of cells differ from previously expressed cells, previously described cells? Are the cells novel, or are you merely characterizing a previously known population? So when you're doing experiments working with cell populations as your invention, it's important to keep these type of questions in mind, because approaching them while you characterize your invention may help and facilitate patent prosecution and grant eventually. Next slide, please. So if your invention is a cell therapy product, it is important to also consider whether it's an autologous or an allogeneic product, because this will have some bearing on how we can define and protect the product. So for autologous products, wherein the cells would be similar, genetically similar with the recipient, so the recipient is the donor, we're often dealing with patient-specific products. So each therapeutic product is specially made for that patient. So the question is if you can define the product in general enough terms to cover this autologous aspect and still for the product to still be patentable. And need to consider whether functional features are sufficient, or you need to include structure features. And also in these instances, it may be of great importance to protect the method for obtaining the product. On the other hand, allogeneic product, wherein the cells are genetically dissimilar with the recipient, we have the potential of actually having an off-the-shelf product, so to say. So product protection per se may be very, very important. But of course, as well, in this case, also production methods are of large value. So again, here's the question of how to define the cell product. How does it differ from other known populations? And also to consider donor matching. Is this a product that needs to be donor matched? And are there any differences between the products? And can the product be protected irrespectively of said differences? And then next slide again, please. And if you're working with a method, well, if you're working with a method, for example, for producing a cell population, you need to consider what steps of your method are key for obtaining the advantages of your method. Do you need to perform the whole method, steps A to Z, or is there some key steps that provide the advantageous effect? And in order to be able to patent methods, it may be useful to provide data that compares the results obtained from your method to the results from known methods in order to show that your method is advantageous. And you also should consider whether your method results in a product that is different from already known products. And if so, how could that product be distinguished from other known products? Because the method may impose some specific characteristics to your product. And if that is the case, it may be possible to protect the product as such. So for cell therapy products, the European Medicines Agency gives regulatory approval, and from their regulatory perspective, characterization of cell populations requires several different characteristics to ensure a reproducible product. One of those is the production process. So this is another reason why it may be very valuable to have protection for a method for producing a production process in this field of technology. And I'm going to hand over to Louise to continue.
Okay, thanks. Thank you. So those were really, really good presentations, I thought. So I'm going to try to go ahead from here and talk about how you manage the rights that you may acquire in your business or in your academia, in your studies. So next slide, please. If you want to move from idea to profit, I have suggested these stepping stones then. When you've created something which is very cool and useful as a result in a project. That is actually just the first stepping stone. So the second step would then be what Joanna and Ylva just talked about, analyzing and protecting those results. So that is one piece of the puzzle, securing your intellectual assets and then turning them into a portfolio of IP rights, intellectual property rights, perhaps in a company or perhaps with you personally. And by doing so, you've completed then step 1 and step 2 of this little scheme here. So step 3 is actually the how. And that is really about controlling your business relations by strategically using the IP rights. So next slide, please. So why do you manage your intellectual properties? Well, it is to strengthen your business position. So there's absolutely no use whatsoever to just secure and patent your inventions or your results to put them in a drawer. That's basically the most expensive thing you can do in your life. So you want to strengthen your business position and use those IP rights to control relations, controlling your relations with competitors, with perhaps suppliers, people you collaborate with or entities, and your customers and so on. This is it's also about knowing then when to keep a secret, when to disclose information, and disclosing information only for the right reasons. Ylva promised I would speak about NDAs a bit, and it's really to that point. You need to be able to control the information. If you have to disclose information and that information is not patented yet, you have to do that under secrecy agreements. That's the only way to protect yourself and also keep the possibility of patenting perhaps at a later stage, although we would strongly suggest that you patent before disclosing. But if in case that's not possible, do make sure that you have a really good NDA. And when you do disclose information, do it for the right reasons and under controlled provisions. And this is why you can never pull out a template agreement from the internet and say just, well, let's just use this NDA and it's probably as good as any other, and then that'll save you money on lawyers. In that current situation that you're in, and under those reasons for you to share the information, that may differ a lot from that template NDA, and that leaves you wide open to a major risk. Because if you're not patenting your information and you're disclosing it without the right secrecy agreement, then it's free for all. Then you can't go back and say, well, that was mine, because you haven't protected it. So the information as such doesn't really belong to you unless you've claimed it in a patent. So you use your patent or your other IP rights to block your competitors, to say, well, this is my property and you may only use it if I allow you to. You control that situation. To use IP rights also means to make sure that you are not infringing in other property owners' rights. You ensure that you have freedom to operate. And this also means for certain research purposes and anywhere where you're going to use others' patented information, make sure that you have a right to do so. When you are in a situation where you need to buy information or materials or something from your supplier, your own patent may actually give you some bargaining power. Because what you're going to do with your suppliers is that you're actually going to exchange information and teach them something. And if you control your information, then you can say, well, you can sell this to me for this purpose. But remember, that is my patented territory. So you can't sell that to somebody else for the same purpose, because that purpose is mine. It's also obviously a possibility to add revenue stream. You can license your information. You don't really have to have your own product line. You can license the information, the patent, to somebody else to use. You can sell the patent as such, as a tangible right or an intangible right that you can use as a trade. And of course, if you have side ground, things that are really not within your business plan, then you can patent and sell that patent to somebody who has that within their business plan. Patents are also a very, very important feature use in any innovative collaboration. If you are collaborating with another party and you're sharing background information, if you have not patented, secured those intellectual assets to make sure that you own them, well, are you really going to be sure that these other parties are not just going to keep using that? Regardless of a good NDA, a patent would be stronger in that situation. And of course, investors' first question may very well be, well, have you secured these rights? Do you have a patent? And they are probably most interested in knowing that they can get return on their money. And often it's this first point about blocking others that is most obvious then in that situation. So you need to understand your third step even before you go out there and patent your results, because you need to know why. What are the parameters that are important for you in your business plan, in your business situation, to make sure that you actually target the right innovation in your patent, to make sure that you secure the intellectual assets that you need in your business. So that's what I wanted to say as regards managing intellectual property rights. And I would like to turn over now to Heather again.
Yes. Great. Thank you for being short, snappy, and interesting. We're going to go over to Mathias, but I have some questions I'm going to bring up later, Mathias. But I'd like to hear a little bit from you first, Mathias, on your background and how you've sort of ended up in the position that you are now. Just to kind of start off so people understand who you are.
Okay, yeah, sure. So I did my PhD at Karolinska Institute at Laboratory Medicine, and I was working in a gene therapy group, and we were writing quite a lot of patents on non-viral gene therapy. So I was learning about patents at the early time point, and it took me quite a while to understand that you don't have to write it as a paper. You don't need to have duplicates of everything. You can say that we think this might be good and claim a lot of things, and then started to claim everything. And now I hope I'm starting to find some kind of balance. NextCell Pharma is the cell therapy company, and we started as a cord blood bank, saving stem cells from newborn, and that was something that was very important for me during my PhD because my wife got pregnant, and I started to read up and just had to save the cells for future use. So that made us start Cellaviva as a spin-off from Karolinska Institute, and the purpose of saving your stem cells is not just having them frozen, it's to find new ways of using them. So as soon as we have established the stem cell bank, we started to look at what kind of therapies could we offer using these cells. And as Joanna was talking about autologous versus allogeneic, for having a good drug, it's very complicated to use autologous cells. So we have looked at the possibility of using mesenchymal stromal cells for the immunomodulatory effect, which is not necessary to match the HLA types. So we are developing a mesenchymal stromal cell based product called ProTrans for treatment of diabetes, and we're also entering COVID. So in this process, we have written 3 patent applications on the subject of selecting the optimal stromal cells for production of ATMP.
Okay, so you were kind of introduced to the concepts of patentability quite early in your academic career.
Too early, perhaps.
Too early.
We have interesting results. Please write something. And that's tricky.
Yeah, no, because that actually, and I'll ask you a question while we're in that thread. When it comes to like CD34 positive cell expansion and these kind of processes that were in place and in clinical use before the ATMP regulations that then became ATMPs, but there wasn't really patentability around them. I guess I could throw that to the entire floor here of, I know that in the ATMP field, particularly in sort of blood areas and in the skin graft burns and some of the MSC technologies as well, that there's a bit of a struggle to actually develop a commercialization plan. And then even as you were saying, Louise, in terms of the business planning, if you're an academic or if you're a clinician, who does this? Who takes the time? Who develops the experience to actually, you know, identify the patentability and then pursue the business plan? I think there's a little bit of a, maybe not a fight, but for people to be experts in all of these fields, I imagine is quite difficult. And when the regulation changes on top of your head, how do you get around that? Are there tricks to securing IP in something that seems like there's nothing there? That was a long-winded question.
And I don't really know who it is really directed to, Heather.
Everybody
but
looks scared.
I could just no, but I mean, if you want to make business of your results, that has to be a clear goal for you, because you know that starting up a business is extremely time consuming, and it you got to give everything you have to make it work, of course. And feeling that this is a moving target is, of course, adds to that stress, I guess, and that's where we come in. That's where you use a consultant to ventilate and to discuss, is there actually a business opportunity in this? Can we do something? Can we secure something that will be strong enough for me to have a business partner, a customer, or a possibly a purchaser of this? You don't have to do everything by yourself. And there's quite a bit of state aid, governmental money out there to get, at least when you're starting. So I'd say that that's perhaps part of the question, or the answer to the question.
Yeah, I could fill in a little bit. I mean, most universities have incubators, or everyone has. So you can turn to some kind of innovation office and have a first sanity check. Then, just like Louise said, there are a lot of IP checks that you can get from Vinnova, etc. So I think that using the resource, there are a lot of resources and there are a lot of organizations that are there for you to get help as a scientist and researcher, and hopefully you will get some funding and you can reach out to the experts in the room.
Okay, so you would say that there's no dead ends. If you have a product, if you have something that's effective, there will be some way of protecting it and some way of turning it into a commercial venture.
Yes, it's in the interest of the university and all the soft money that is out there. So yes, yeah, that's the whole idea of the Swedish life science. I mean, Sweden got like 57,000 patents. We are world champions in patentability, I guess.
Yeah, and I'm just going to add to that and say this is all true, but it's so important to remember not to disclose your invention prior to entering this process, because as an academic, you're quite often on conferences, giving seminars, and if you want to follow the track to take your idea into a business, you need to make sure that you do things in the right order. And one way of destroying your opportunity to protect your invention is actually telling people about it before you've secured the rights to it.
Yeah, now that's where I was wondering if, you know, like with the burns type ATMPs, where it was established before the ATMP regulation, so it didn't require a business model before the ATMP regulation, and so then it is, I guess, disclosed because it's already being used in clinical practice. And so then how, now that you've had this regulation put on top of you, like, are there tricks to creating some step in the process or some device or some delivery or to developing it again into patentability?
Of course, I mean, if you make improvements of existing technologies, you may patent them and build your business around that improvement as your technology. So just because something is already out there, it doesn't mean that it's a completely, impossible to develop a business plan around that type of a technology implementation. You just need to find something additional. You may protect improvement inventions, and most inventions that we actually work with are improvements of existing technologies.
Yeah. Okay, with that question behind me, I'm going to hand over to Mathias now and let him have a chat with our experts.
Yes, thank you. So I would like to start off by asking Louise about NDA. That seems to be the starting point of every discussion. And we have a template that we use, which has like 2 or 3 lines that we exchange depending on who we are going to talk to. And we write a lot of NDAs. I think we got the template from Karolinska Innovations like 15 years ago. I understand it's not perfect, but I don't want to spend thousands of crowns for lawyers. And also, it's usually very short timelines. You want to talk in an hour, you sign it just before. Do you have any suggestions how we could improve that?
I think that you actually may already have given me the answer to the question, because you say we have a few lines that we exchange. You need to be an informed buyer or an informed discloser in this case to know what is the purpose of sharing secrets with that other party, and make sure that they can only use the information for that purpose. So the worst NDAs I've seen are actually ones that say, well, everything we say during this meeting is confidential and you cannot use it for anything. Well, fine, what are we talking? That's totally useless. If I can't use that information and go back to my organization and say, hey, I met these cool guys, then what's the purpose of me knowing this? So will you both be sharing secrets? Then you need it to be mutual. Or will you actually be creating something together? Then an NDA that says that whatever I disclose to you is secret and you disclose to me is secret. What we create is then left out. So make sure that when you read through the template that you have, make sure that it actually covers the situation you're in. Also know what kind of information are you sharing? Is this business, technical, or other? Because if you're talking for the purpose of perhaps a business decision, then maybe you don't have to disclose technical information. Then don't say more than you have to under this situation. And I guess that's a first and a given, not to disclose more than you have to.
Okay, thank you. I think, yeah, it's hard because you really like what you work with and you want to explain in detail how it works so everyone can understand how fantastic it is, but maybe we should be a little bit more modest then.
Well, mitigating risks, I guess. Yeah.
Yes, I got a question here. From the legal perspective, are there any other concerns apart from confidentiality to consider when collaborating with others?
Yeah, definitely. Ownership of results is my primary, and access rights, both to results then and to background information. So when we collaborate and we do something, does it matter who has the actual inventive or actually makes the invention, or are we going to own this together jointly, or are we going to share it depending on our business perspectives and business needs? And if we actually come up with some really cool results, if those are based on my background information, will you be allowed to use my background information to work those results in your business? Not necessarily. So ownership and access rights are two primary. but also we had a lot of academia people joining us today. Dissemination and publication is really important. And if you're working in a project that has perhaps quite a low technology readiness level, then it may not be enough that you're granted 30 or 60 days to patent, because that's not useful to you. There's nothing to patent, this is too soon. We need to make more data and so on.
Okay, thanks. And we spend a lot of time writing the agreements, really looking into the details, trying to be thinking of all these aspects. But once it's signed, we put it in the archive, and if nothing else happens during the time of the agreement, we will not revisit that. Do you have any thoughts of how to work with your agreements?
Yeah, a couple. One would be to make sure to keep track of agreements who may actually have an expiration date. Some NDAs do, and then you just go on working with that other party. Say, well, you know, we have an NDA, and that expired already, so that's no good to you. So make sure that those are still valid, the ones that you're still using, and make sure that the party with whom you signed that NDA is actually the same party that you're still collaborating with, because things tend to evolve, and sometimes you don't really consider the fact that this company was now bought by that company who then transformed into, and so on, and they shared or they divided into other entities and so on, to make sure that the parties are still the ones that signed the agreement to start with, so that agreement can actually be enforced if you need it. And then, for example, with MTAs, when you're granted the right to use somebody else's material for a specific purpose, I mean, a lot of researchers work on different projects, and they have their fields of speciality. So it's not uncommon that you work on several projects simultaneously, perhaps. Make sure that you actually have these Chinese walls between these, so information doesn't flow, and that the material that you're given to use for a specific purpose doesn't end up being used for something else or in another project or so on, because not only are you breaching that material transfer agreement, you're also creating results that are completely useless because you're not allowed to use them. So you put your energy and your money into something that you have to throw in the trash bin.
Okay. we need to systemize that. So Joanna, I have a question here from the chat that, do you need clinical data when filing a patent application in the ATMP field? Is there something specific to consider?
I mean, this might seem as a silly answer, but more data is always better than less data in a patent application, obviously. And if you're dealing with an invention that relates to treatment of a disease, I mean, clinical data showing efficacy would be optimal, but it's expensive and it's time consuming to obtain that. So depending on the case, normally in vivo data from a well-chosen model works just fine for patent purposes. And in principle, even in vitro data may suffice. However, in this case, it's really important to be able to establish this thing I call plausibility, the extrapolation of data. So to choose a suitable model is crucial, and you need to sort of establish that a person that is skilled in the art would believe that your invention would likely work to treat the disease based on the data that you've obtained in your model system. And here it's also useful to include a scientific reasoning in addition to the data that is described in the application, so that you kind of help along this plausibility aspect. But generally speaking, just like you said, Mathias, before, data for a patent application maybe in the form of pilot experiments, in contrast to that scientific mindset where you want data in triplicate with statistical significance and so on and so forth. The requirements are less strict for the purpose of a patent. And as I mentioned during the talk, if you would like a wide scope of protection, it is advisable to have a lot of different examples of your invention and where you show that you achieve the technical effect of your invention instead of in-depth analysis of a very few examples. So yeah, any follow-up questions?
The more the merrier.
The more the merrier, exactly.
Yes. And this is, I mean, it's also a moving target when it comes to your product development sometimes. This might be a question for Ylva that, when, for example, we file our first application to get our priority date, and then before sending in the second application, we have generated a lot of new data, even data that was perhaps out of the scope from the first application. Can we add something?
Yeah, you can add anything really, but it is associated with a risk because anything that was not there in the first application will not have the priority that you claimed. And I mean, there may be new prior art that was published between your first priority application and then your second. But typically, we advise our clients to add further experiment on the same invention to show that it works. Like, for example, if you had only in vitro data in your first application, then you can add in vivo examples within this priority year, and that's really good. And you may also add the comparative examples that shows that your invention works better than something from the prior art, that it has some kind of surprising effect. And I think that this is a way to like increase the plausibility of that the invention works as intended.
Because I think there were.
Sorry, can I add a little bit to Ylva's answer? Because
yes, of course.
Ylva, or maybe Ylva wants to expand on this. I was thinking about that we quite often, together with our clients, where the client has a plan about what experiments they will plan to perform during that priority year. We draft the hypothetical examples. Ylva, would you like to continue on that?
Yeah, absolutely. So like normally when we draft this first application, we ask our clients what they intend to do with the invention during the coming year. And if they intend to do further experiments, they may be added as those hypothetical experiments, which is basically like you writing up what you intend to do and also what you intend that the results are. And then you can add the results to the second filing.
So you could put in your clinical trial data, so to say, before you achieve them. And then comes COVID and everyone wants to add something about SARS. Can you add such totally different things if you are, as we have been working in diabetes, and we want to apply it on the thing like COVID?
Yeah, you can add anything, but I mean, then you will not have this priority because it's not there in the first application, because now you have like a new embodiment.
Okay. So it's.
I mean, and this can be a problem, or it is not a problem depending on what's been published during that priority year. So it's a little bit case dependent if it's advisable to add those type of completely new embodiments. But I mean, yeah.
But as soon as I file, then I can publish, right?
Yeah. Yes, the principle, yes, you can. But we usually we advise our clients to think through if they are disclosing anything more than what's actually disclosed in the patent application. Because like if you have invention A, then you have an article on exactly invention A. That's totally fine. But maybe you also disclose some kind of development of A, say A prime, in your article. then that could be a problem if you in the future want to follow up invention. And you could also get into problems if you start discussing that, like, oh, I could use A for in this specific field or use for this feature, and then later you conclude that you would like to file an application to that specific use. Then you will get the article as prior art against yourself. So yeah, absolutely. you can publish, but you should consider like the patent scope that you would like to have in the end. And I mean, if we as attorneys could choose, we would advise you to do after the PCT filing, but we are aware that this is not always possible.
No, I guess you reveal a lot of thoughts in the discussion section of the publication for future possibilities. I would like to end the questions by asking Joanna if you have observed any trends regarding patent filing in the cell therapy area.
Yeah, I mean, a number of years ago when cell therapies were all new, and there's like with any new field of technology, the patent applications had very broad protection scope, and it could sound like something such as a composition comprising cells that or cells expressing CARs that are able to bind to CD19 for the use in treatment of disease associated with CD19. So very, very broadly defined inventions. What we see now is a tendency towards improvement inventions. And the protection scope of those is more narrow. It's questions of, for example, overcoming problems with the current technology, such as toxicity, problems relating to, or inventions relating to solving problems in terms of biological problems, infiltration of tumors, overcoming the tumor microenvironment, and improvements in production methods, and so on and so forth. And what is important in these type of applications is that the patent application includes comparative data when you're showing that your new technology is an improvement above the old technology, kind of benchmarking yourself and establishing a technical effect. I'm going to keep this really broad, short, because I see that Heather wants to interrupt.
I always do.
Yeah, you do.
Oh, you're finished. Oh, that was your brief.
Yeah,
like,
no, I
done.
was like, yeah, that was like my brief time. Brief
Okay, thank you. Well, that was great. So if anybody still has questions, please feel free to drop them in the chat now. Of course, you can get in contact with me directly or Joanna. We're recording this and we're going to have it available on our website, atmpsweden.se. And then we also have a bit of a like standalone version of the presentation, which is a bit more extended and wordy. So you can kind of read back on some of the things that have been discussed and get some more details. So with that, thank you very much to the speakers. Thank you, Mathias, for hosting the discussion. And we look forward to developing more resources in the future to make this accessible to people and to try to help people to actually do this when they have very busy research, product development, and clinical lives, because this is important. Right? Okay, thank you very much, everybody.
Thank you.
Thank you.
Thank you.
Bye.
Bye now.
Bye.